This meeting is being recorded.
Okay, good morning, everyone. I'm going to continue to admit a few people. I'm so glad to have you all joining us back to our regular scheduled programming with Christine and Kyle joining us today. I hope y'all were able to access our pre-recorded June Clear Up the Chaos. We were able to do that ahead of time since they were at a convention and learning valuable information to share with us. But I'm glad to have us back on schedule and having Christine and Kyle join us. We have a full action-packed schedule per usual to bring y'all value-added information. So I'm going to hand it over to Christine. If you do have questions, I just want to remind everyone you can send those via the chat box, and I'm happy to relay those. I know that some people had already submitted some questions regarding some of the overtime rules and what that looked like per some industries. So Christine and Kyle have already been given those questions, and I believe they will be addressing those. But if additional questions do arise, please feel free to send those via chat. And if you haven't, if you would kindly mute your computer just so everyone can hear Christine and Kyle presenting. But Christine, I'm going to hand things over to you so you can get started.
All right, thank you so much. You guys can hear me okay?
Yes.
Awesome. Well, good morning. It's great to be back. I know it's been a while since I've been presenting on the monthly Clear Up the Chaos. So thank you for having me back this month. As Elizabeth mentioned, we have a lot to talk about, so I'm going to dive right in. We did attend SHRM conference, so the Society for Human Resource Management in New Orleans last month, and I believe all 4 topics that we're covering today is late breaking kind of content from the conference. So first up is the Department of Labor's new guidance on prohibitive retaliation. So I'm not sure how many of you guys might be familiar with the Department of Labor issuing field assistance bulletins, but it is a tool that they use, which is very common in government organizations, to provide guidance out to their workers and their staff, those investigators, adjusters and things, on clearing up any laws or regulations, whether it be based on court decisions, changes, or just general opinions of interpretation by the Department of Labor's various administrators. So back in March, and I know that might seem a little dated, but we've definitely had full content since then with so much going on. But back in March, there was a new bulletin issued, and that bulletin was 16 pages, and it really dived into prohibitive retaliation. And to give you some context, there's been 4 bulletins issued by the Wage and Hour Division so far in 2022. 3 in 2021, and then 8 in 2020. And again, a lot of those in 2020 were going to be COVID related bulletins. It was various interpretations on how to navigate all the changes that were occurring. So the bulletins are few and far between. They're not common. So when these bulletins come out, granted, it's written as the audience being their staff, but they do publish them for the general public. And part of our responsibility, whether it be in leadership or in HR, is to read these bulletins and understand them, because it gives us direct insight into what these organizations are thinking and where perhaps they're headed. So in this particular one, it gave some background context. It reminded the reader of the role of Wage and Hour Division. Then it defined again retaliation and what they said in terms of retaliation. This was the definition. Retaliation occurs when an employer, including through a manager, supervisor, administrator, or other agent, and that's the part I want you guys to remember, or other agent, takes an adverse action against an employee because they engaged in a protected activity. So we'll come back to that other agent. And in addition, the bulletin also talked about the definition of protected activity. From there, the bulletin was in sections, and each section was basically what was prohibited retaliation under each particular act that the Department of Labor Wage and Hour Division is concerned about. So the first one was the Fair Labor Standard Act. And the Department of Labor, and again, this is kind of that high level overview. Employees are protected from retaliation regardless of whether the complaint is made orally or in writing. And I don't think that's really news to any of us. We know that complaints can be made in various formats. Complaints made to the Wage and Hour Division are protected, which I think we all would understand. But they go on to say internal complaints to your companies are also protected. Employers who willfully violate the Fair Labor Standards Act may be prosecuted criminally and fined, imprisoned for not more than 6 months or both. So that's kind of just, again, some restatement, but I think it's good context to understand why they're really honing in on the importance of employers following through with the requirements of the FLSA. The regulation prohibits any person, again, that goes back to that definition of retaliation of other agent. So this bulletin was really used to define that it goes beyond just HR. It goes beyond the CEO. It goes beyond your managers and supervisors. So it prohibits any person from retaliating against any employee. And what they said is any person does not need to actually be an employee of your company. And they pointed out some specific examples. They said, if you guys have outside counsel, they're acting as an agent on your behalf of your business. So they would also be included in that any person. And they even cited, which is, I've been trying to brainstorm an instance of where this may come up, but they said even the employee's former employer would be considered any person. So I'll be curious to see if over time that evolves, that particular scenario. Anyway, so they were really honing into their staff on casting a wider net on who could be held responsible for retaliation against an employee at your company. They gave 2 examples, scenarios, and I think it's worth talking through them. So Nelson works as a cook at a restaurant, contacts the Wage and Hour Division confidentially to inquire about overtime pay. Nelson then tells another cook what he learned, and then his coworker tells someone on the wait staff. Later that day, that their manager overhears 2 wait staff talking about the call and then goes on to terminate Nelson's employment. So again, that one is probably a little bit more clear cut. You know, if we just hear someone's filing a complaint and then we go to terminate them, obviously that's retaliation. So I don't think there's going to be any confusion about that example. The other example, though, I think is really interesting on the topic. So let me walk you through it. Aisha is a new mother who works for a call center. She uses her lunch break to express breast milk and needs additional time to finish pumping before she's able to return calls at her workstation. Her boss complains when she is late returning from lunch and tells her she cannot use any time beyond her meal break for personal stuff. When Aisha asks if she has a right to take another break for pumping later in the day, her boss sends her home for the rest of her shift without pay. In this scenario, Aisha was sent home for attempting to exercise her rights under the Fair Labor Standards Act. After investigating, Wage and Hour Division, in addition to requiring the employer to provide the requisite time and space for nursing mothers in compliance with the law, determines Aisha may also be entitled to back pay and liquidated damages for wages she lost when her boss sent her home in retaliation for requesting a break. Why I think this example has significant meaning is that they could have picked any kind of scenario, but the fact that they use breastfeeding and that protection for breastfeeding breaks, I think is also of interest. I think they're going beyond using this example for breast breaks, being able to use that time for pumping, but I think they're also sending a message to their staff on protecting the rights of nursing mothers. So if if this is something you come across in your workplace, I definitely encourage you to get familiar with the regulation. I definitely encourage you to reach out to us. Let us help you navigate this, because I think this is sending a message to their investigators to look out for these scenarios as low-hanging fruit to go after employers. Okay, so that covered kind of what they talked about under the Fair Labor Standards Act. The next big section, which I think applies to just about all of us, is what is prohibited retaliation under FMLA. So the definition within FMLA and the actual words in the regulation, it says FMLA prohibits interfering with, restraining, or denying an employee's exercise of or an attempt to exercise any FMLA rights. The law also prohibits employers from discharging or in any other way discriminating against any person, whether or not an employee, for opposing or complaining about any unlawful practice under FMLA. So again, they're really showing and demonstrating, they're casting that wider net of who can form a complaint or lodge a complaint against employers for not complying with FMLA. So it's no longer just Kyle can complain about Ironwood if we're not giving her her rights, but perhaps I notice Ironwood is not giving Kyle her rights. I can file a complaint on Kyle's behalf without Kyle even being aware. FMLA also prohibits an employer from discriminating or retaliating against employees or prospective employees who have sued or have attempted to use FMLA leave. If an employer's failure to timely designate FMLA leave as required by the regulations causes the employee to suffer harm, it may constitute an interference with, restraint of, or denial of exercise of an employee's FMLA rights. And I think this is a key clarification that they're restating for a reason. So as an employer, you have an employee that's sick and you are subject to the requirements of FMLA, and you have not provided the employee with their notices, and you haven't started that FMLA conversation, that could be basically construed by FMLA as retaliatory or interference, denial of the employee's rights. So I think that this is really worth stating that it's a reminder of the obligations we have to train our supervisors to notify us of those instances when employees are out of the office, and that leave might be something that's protected under FMLA. So it definitely was worth mentioning those examples. The bulletin actually talks about two instances. The first one, Jamie takes approved FMLA leave to care for his 7-year-old daughter when she is in the hospital overnight and recovering from surgery. Jamie returns to work as scheduled, but receives 3 negative attendance points for the days he used FMLA leave. Under his employer's no-fault attendance plan, employees are allocated points for every absence from work, regardless of the reason for the absence. Employees are disciplined when they accrue a set number of points, and employees who accrue more than 10 points in a calendar year may be terminated. So this company has a clear attendance policy. It sounds from this example that they follow it to the letter of the law. But in this scenario, assigning Jamie attendance points for his FMLA protected leave days would be prohibited. So this would be considered retaliation. And again, Kyle will probably nod her head. We receive calls like this situation very frequently. However, what is unique is that a lot of our employers are not following through and actually designating Jamie's leave as that protected leave under FMLA. They just, Jamie's off. So again, thinking about those prohibited statements and what is the wage and hour division more inclined to do in this instance? Are they more inclined to side with the employer because the employer is following their policy to the letter of the law? Or are they going to be more inclined to side with the employee in this instance? And I'm going to tell you, they're going to side with the employee because Jamie's FMLA rights were not exercised. So something to keep in mind. And then the second example, Deborah uses FMLA leave from her job as a front desk clerk at a hotel when she suffered from migraine headaches that made it impossible for her to work. So this is one of those situations of intermittent FMLA. She was approved for FMLA leave and used it for 3 days in January and 1 day in February. In April, she has another episode and used FMLA leave for 2 days. When she returned to work, her new manager reduced her schedule from 40 hours to 20 hours a week, saying they need workers who will show up every day. Of course, Wage and Hour does their investigation. They require the hotel to return Deborah to her previous position, previous schedule, and they also require to pay her lost wages and liquidated damages. So how often does this happen? Well, we have that change in supervisor, and of course, they want to run things a very different way than that previous supervisor. Well, in this case, that new supervisor being unaware perhaps of the arrangement of the intermittent leave was set up for failure. I mean, this is another one of those examples of why your supervisor training program is so critical. So those were the two regulations in the bulletin that I wanted to cover. Again, this bulletin was 16 pages, and what I just highlighted was just the high points of the first 5.5 pages. The bulletin covered things like the Migrant and Seasonal Agricultural Worker Protection Act that covered visa programs. It covered federal workers and federal contractors. There's a lot more content. And so what I planned on doing was shooting Elizabeth the actual link to the bulletin following today's session to get out to everybody. So that way you guys can take a look at it and do your own reading. All right, that wraps up our first topic. I'm going to turn it over to Kyle for our next one.
Interesting. So our next topic is examining hostile work environment claims. There may be some confusion on what actually constitutes a hostile work environment, and we wanted to give some examples of what would and what wouldn't be considered a hostile work environment. So a hostile work environment exists when an employee is subjected to unwelcome harassment that is sufficiently severe or pervasive enough to alter their working conditions and create an abusive working environment. There are two requirements that must be met in order to be a violation of the law. The conduct must be severe or long-lasting enough to create an environment that a reasonable person would find hostile or abusive, and it must be based on a protected classification. So that would be race, sex, age, national origin, disability, religion, and sexual orientation. Isolated and infrequent instances of misconduct would not necessarily be considered a hostile work environment. What most employees think is a hostile environment is typically not. While certain instances may absolutely violate a company policy, it is not necessarily a violation of the law. So some instances that may qualify: repeated use of racial slurs, especially when mixed with threats or violence; possibly repeatedly telling an older employee to retire early or take off their wig. That was an actual court case that I reviewed. Unwelcomed intimate or sexual conduct, overt invitations of sexual conduct or activity, or intentionally sabotaging an employee's work or career. Instances that typically do not qualify. So that might be the use of profanity, especially if the profanity does not include racial or ethnic terms. That might not be enough to be considered a hostile work environment. Seductive looks and just clumsy attempts at flirtation might not qualify if limited in number and not involving inappropriate touching. Showing disrespect or talking in a demeaning fashion to a subordinate, like yelling or name calling, will not qualify absent a nexus to a protected classification. Teasing, bullying, gossiping, or ostracizing from coworkers may not qualify. Taking disciplinary action against an employee, even if unjustified, might not qualify. Assigning a heavy workload to an employee is not a qualification of a hostile work environment. Requiring an employee to be at work on time and meeting production quotas is not a qualification. Requiring or closely monitoring an employee's work and breaks does not necessarily qualify. And refusing to remove stressful tasks from work responsibilities does not qualify. So how do you handle any incidents of hostile work environments? The first thing is to establish those written guidelines and policies. Every organization should have an employee handbook and code of conduct. With written guidelines and policies reinforcing positive behaviors, it should be extremely clear how employees can and can't act in the workplace. Holding mandatory trainings, consider ways you can further educate your employees through training sessions. For example, organizations implement mandatory workplace harassment and discriminatory trainings for all employees and not just managers. Investigate every complaint. Failure to investigate a complaint can result in a negative consequence for your organization. No matter what, take every complaint seriously and do your due diligence. Hold people accountable. Addressing any misconduct is critical to preserving the integrity of your organization and protecting your employees. Take actions and hold those accountable who have perpetuated that bad behavior. So there are plenty of different court cases that they have clearly defined what is and what isn't a hostile work environment. And some of the confusion is pretty clear when we do get certain calls about employees, maybe not having the best working conditions or having an issue with a manager, and they are afraid that it's going to be a hostile work environment claim. So something like, my boss wrote me up for work. Doesn't he understand that there's traffic? That's not a hostile work environment. My manager only gave me a meet standards on my annual review. That's not a hostile work environment. My boss yelled at me and called me an idiot is not a good example of a great management tactic, but it is not necessarily considered a hostile work environment. My coworkers won't speak to me, but they gossip behind my back. Again, that's not necessarily a hostile work environment, but something that needs to be addressed. My sales manager told me if I do not make my quota this month, I could be fired. I can't work under this pressure. That's not necessarily a hostile work environment. Some specific examples taken from actual court cases would be, there was a supervisor who was mooning his employees and exposing himself to subordinates and requiring them to receive kisses in exchange for paychecks. That is absolutely a hostile work environment. Repeatedly referring to a female employee as the B word and threatening to punch her in the face was an actual court case, and that is absolutely a hostile work environment. Repeatedly calling an older employee an old man or pops and telling him to go talk to his religious God and see if he can save his job. That was also a hostile work environment. So that is some of the clear cut rules on how you determine if there is a hostile work environment claim potential. So a big part in making sure to protect your business is that taking that action, investigating those complaints, and also providing detailed documentation on every instance that might occur. So that's the segue into my next topic, which is how to develop detailed documentation. So proper documentation is vital to the success of a company, and it can greatly protect your business. Managers are repeatedly told you need to document, but too often they don't know exactly what to document or how. And that becomes a problem, particularly if an employer or employee case reaches a trial. This is particularly important when it comes to discipline and termination. So why is it important? It makes a record of performance history to use as an added protection if you do let someone go. It shows that all employees are treated fairly and consistently. It shows the steps the employer takes to help an employee become successful. Writing disciplinary documentation is not just to punish the employee, it's also to make that detailed plan on how to make their work life more successful and show them the right steps to take in the future. It also clearly defines expectations moving forward to eliminate confusion and any repeated behavior. And it also serves as just a general reminder and gives a history, especially if you have a new manager who might not know the backstory, and then they can go back to the documentation that they have on that employee and make better, more educated decisions in the future. So it's a big question on when should I document something. So let's say an employee is 5 minutes late. It's their first time that's ever happened. Does that automatically result in a write-up that you should document and have that conversation with the employee? Not necessarily. Our guideposts would probably be the things that happen more than once and being able to pinpoint when that started to happen. And when you are writing your documentation, it is really important to not include certain words like weakness, shortcomings, inadequate, failure, failing, and fail. Those words can be construed as opinions and they have different meanings to different people. So when you are writing this documentation, describe the conduct and not the individual. Try and avoid slang and absolute words such as always, every time, or invariably, and never, ever, ever backdate. If you're sitting down and having that conversation with an employee, it's important to document at that time when you're having that conversation. And if you are unable to, for any reason, when you're officially able to make that documentation and write it out, put within it that you had this conversation on Tuesday, July 12th, if you're doing it tomorrow. So there are some really helpful steps on how to make sure you develop that strong documentation process. So the first thing you want to do is just describe the expectations, and expectations are everywhere. They can be in your policies and procedures, they can be in the job description, they can be in the manager's company goals, and also within the law. So describe what is expected first from that employee if it's a disciplinary action. And like I said, avoid that sloppy slang of using things like always and never and things like that. The second best rule for documentation is to describe the behavior or performance that must change. So after you describe the conduct, keep your observations job related, and use objective criteria and describe the impact that might have on others, both positive or negative, and be specific. Give detailed examples of behavior that you want to change and what a change would look like. The third best practice is to include the employee's explanation of why expectations are not being met. So it's a two-sided conversation. Get their point of view. It's fair, and you might be surprised what you actually learn and are able to fix by just asking their opinion. And it also provides that opportunity to help correct the performance and give success later on in that employee's career. So the fourth rule is to detail the action plan and the goals. So what are the steps the employee can take to improve the performance? Steps managers and supervisors can take to assist the employee, and reaching an agreement with the employee that from here on out, this is what is expected and this is what we're going to work towards. The fifth best practice is to include the time expectations for correcting behavior or performance, but be realistic. Be careful about including things like 30, 60, 90 days. Consider shorter timeframes with a few areas of focus. And if you do include a time frame, then you must follow up. But consider leaving those expectation times open. The next best practice is the follow-up. So you put all of these discussions in place, and when it is time to talk to the employee, whether if you did use the 30, 60, 90 days, you be sure to follow up and make sure that it is working. And if it's not, you can reevaluate maybe what's next steps to take. And you might have to amend your documentation as necessary. And the final best practice would be describe the consequences if that behavior or that poor performance continues. Try and use consequences deliberately and sparingly. So that might be, it might be better if you use things like coaching and what happens if policy violations or repeated tardiness continues. And it is not always, discipline is not used as a way to get someone just terminated. That it should really be used as a coaching experience more than anything. And you just have to try and use that as a way to better the whole organization rather than just a ways to terminate someone. So that is what I have on documentation, and I'll turn it over to Christine.
Thanks, Kyle. Appreciate it. So now we're diving into exemptions from overtime pay, and this is where we received several questions in advance. So I have those in my presentation. I promise to get to those. So I do want to lay some ground rules though about what I'm presenting. If I were to print this actual code, it would be about 65 pages. So we don't have enough time left in today to go over 65 pages. So, I just want to kind of set expectations that we're going to be at the surface here, but hopefully there's some new information you can take away that'll help you every day. So to be exempt from overtime, a position must meet 3 criteria. And of course, like every regulation, there are some exceptions. So the 3 criteria is that minimum salary threshold, which is the easiest one for all of us professionals to calculate and figure out. Payment on a salary basis as defined by the regulations. Again, that one is a little bit easier for us to navigate. And then the final one is, I think, where a lot of us get tripped up. And it's that primary duty test that is specific to a particular exemption. And when we think about those typical exemptions from overtime pay, we tend to think of those white collar exemptions. We've all heard of that executive exemption or that administrative exemption, professional, computer related, highly compensated, and outside sales. So those are typically the ones that we know to go to and test against. So if our position that we've tested meets those 3 criteria, then we know it's exempt from the requirements of overtime from the FLSA regulations. However, there's a few industry-specific exemptions. I'm not going to go into detail on these, but if this is something that is in your day-to-day work environment, definitely encourage you to reach out to us anytime and let us help you navigate them. So agriculture activities and operations has an industry-specific exemption, and there's a question on that one that I'm going to address later. Commissioned sales employees has its own industry-specific exemption, and then motor carrier employees covered under the Motor Carrier Act of 1935. So then there's some key positions that are never eligible for exemption. These include blue-collar workers, and that's that work involving repetitive operations with hands, physical skill, and energy. Again, that doesn't meet one of those industry-specific ones. First responders, and then inside sales employees. So those 3 type of positions are not eligible for exemption under FLSA. So kind of with that brief context, what I think is important for you guys to be prepared for and understand is that there is a bill that is moving forward in the House for consideration called the Wage Theft Prevention and Wage Recovery Act. And it would change how we do business. So to be aware, if this goes through, it would require pay stubs detailing how wages are calculated. That's going to be a significant impact to all of us. When we think about what's on our pay stubs right now, it's typically, hours, then the resulting pay for those hours, benefits information, maybe some leave tracking, things of that nature. But if you think about if you have those non-exempt employees and they do have overtime, this act would require us to actually show how we calculated that overtime pay. We wouldn't be able to have just a line anymore that said overtime and this much. We would actually have to show how we arrived at it. That'll be interesting, especially for our accounting folks to have to navigate that. This act would also increase monetary penalties for violations per employee. So for initial violations, it would go from $1,100 per violation per employee to nearly double, $2,030. And for repeated violations, they're kind of taking a playbook from OSHA. It would be up to just over $110,000 for initial violations. And then for tip wage violations, so if any of you are in that hospitality industry that has those tip employees, those violations would increase from $1,100 to just over $12,000. That's pretty significant. So they're coming hard for hospitality. So if that's your industry, you should be aware of this act and definitely be watching it close. It would also increase liquidated damages from 2 times to 3 times, and then 4 times if it's due to retaliation. Then it has some final pay language in there, which we know final pay also has particular regulations by state. And the final pay in this ruling would be due within 14 days, but we know a lot of states have other requirements. So that's a regulation we're going to be watching. We definitely think everyone should be watching it. We'll keep you updated as we hear anything, but it's likely coming. So before we wrap today, I wanted to make sure we covered common issues we see when applying these overtime exemptions and then answer those questions. So that first number one issue that we receive is that administrative exemption. This isn't your administrative assistance. This exemption is very poorly named. So one requirement for this exemption is that an administrative employee is that the employee's primary duty of office or non-manual work be directly related to the management or general business operations of his or her employer. So this is not your administrative assistants, your receptionists. They don't manage anything. This is your HR manager, your accounting manager. So it's that person responsible for that general operation of one of your core business functions. So it goes on to say that's the first requirement, and then there's an and statement. And another requirement of the duty test for this exemption is that the employee's primary duty includes the exercise of discretion and independent judgment regarding matters of significance. Sure, a lot of us can sit here and argue that there is some discretion, whether it be for that administrative assistant, that receptionist, but is it a matter of significance? And that's where employers get in trouble, because typically not, whether they're choosing a particular office supply over another, or a meeting location over another, or calendar arrangements. Those typically are not matters of significance. And that's where we see a lot of employers get in trouble. So what I would like to leave you with today is, when you think someone qualifies under that administrative exemption, instead of saying administrative exemption, I want you to replace administrative with manager exemption or supervisor exemption, and think of it that way. If you use that kind of as a rule of thumb, then you're going to set yourself up for success when performing that test. The other common issue that we see here at Ironwood is that failure to pay for all time work. It's that off the clock time. So if you have, which is I think new to a lot of our employers, that non-exempt employee, but now they're working remote, how are you ensuring that they're reporting for all time work? You know, at Ironwood, we have some non-exempt remote workers. When they're checking their email and responding to me after hours or weekend, they have to be recording that time. And I'm quick to make sure that they're doing that. That's something to keep in mind. Work during meal breaks and rest periods must be counted as work time. So let's kind of dive into that a little bit. I'm going to give you guys an example. And the regulation really goes into preliminary and post-preliminary problems. And this is an example. So an employee's shift begins at 8 a.m. Her workday begins when A, at 7:50, when she walks into the plant and submits to a COVID test. B, at 7:55, when she puts on protective boots and coveralls. C, at 8, when she gets to her workstation. I mean, how many managers would we have that would say C? But it's not. Her shift would begin at 7:50. She walks into the plant and she has to submit to that COVID test. That is part of her preliminary off the clock mistake time. That is truly, she's on the clock when, as part of her employment, she has to submit to a COVID test. She is now on the clock. So I want to make sure that you guys are thinking about too that commute time. So let's say an employee is at home because we have that electronic leash now, and at home I'm checking my email and I'm starting to respond to things. Then I go ahead and take my commute to work. Now I'm at my desk and I start working. When have I officially started the clock? Some would say when I actually arrive at the office. Some would be surprised to learn it's actually when I start responding to emails. And now my commute time is also work time. So it's important that your employees, if you want to make sure that it's that in-office time, that you're not creating a culture where we're responding to those emails and starting the clock in advance. Now, if you're okay with that, by all means, don't change your culture, but it's just something to be more aware of. So some things you guys may not realize as we wrap up today, the Department of Labor actually has an online advisor that helps employers navigate these exemption tests by answering a series of questions. They give themselves a lot of caveats, but I will shoot that link to Elizabeth too, so you guys can use that tool. So question one we received, are agriculture workers exempt from overtime? Generally they are. And there's an actual Department of Labor fact sheet on this subject that I will send to Elizabeth for the person who asked this question. Of course, with any part of this regulation, there could be some exceptions, but generally speaking, agricultural workers are exempt from overtime. Question two, are there car dealership exemptions when covering overtime pay if that differs from industries? Again, there is a Department of Labor fact sheet on this very subject that I'll shoot over to Elizabeth. These workers are typically non-exempt. Your managers in that car dealership will likely meet the requirements of that administrative exemption. But it's important to know that the Supreme Court actually came out with a ruling in 2018 that addressed this very scenario. It was in reference to service advisors, and they considered service advisors to be considered exempt. So I will also send that information about that particular regulation and where it's actually pointed out in what section of the Fair Labor Standard Act. So it talks about there are tests to be met for the exemption of salesmen, partsmen, mechanics employed that are primarily engaged during the work week in selling or the servicing of named items. So, and then it actually defines what a salesman is, what a partsman is, and what a mechanic is. So whoever had that question, I want to just not give you kind of a blanket answer. I really want to set you up for success, and I want to show you that Supreme Court ruling and the actual snippet from the regulation. So reach out and we'll be in communication. But just know there are several industry-specific exemptions and non-exemptions when it comes to the Fair Labor Standard Act. So Elizabeth, we're a wrap unless you received any questions.
I have not received any additional questions. I so appreciate you and Kyle being so thorough always. I do want to remind everyone, if you haven't had the opportunity to get me your agreement to have access to these wonderful ladies and their expertise, please shoot me an email and I will get that paperwork sent over to you. But I appreciate each of y'all joining us today. Please save the date for our August Clear Up the Chaos taking place August 9th. And again, I will send a follow-up email with all of these links. And I do appreciate your patience. I know there was some technical issues with some of the sound today, but I do appreciate y'all joining us. And if I can assist y'all in any way, please don't hesitate to reach out. Have a great week.
Bye, everybody.
Bye.